Hello everyone, welcome back to the channel where we simplify complex legal concepts for you. Today we are diving into a topic that is often misunderstood but extremely important. How to apply for voluntary bankruptcy in Singapore under the Insolvency Restructuring and Dissolution Act of 2018. Whether you're considering this step or you know someone who might be, this video will explain the criteria, the procedures and even the forms you need to file. Stay tuned until the end for my commentary on the implications of voluntary bankruptcy. Voluntary bankruptcy is a significant step that should only be considered after exhausting all other debt relief options, such as the debt repayment scheme or informal negotiations with the creditors. Now let's move on to the application process. Here's a step-by-step guide. Number 1, preparation of documents. Gather a list of all your creditors, including their contact details and the amounts owed. Prepare a comprehensive statement of your financial affairs, detailing your income, expenses, and liabilities. The information here will have to be included in Form PIR 11 of the bankruptcy rules. Next step, filing the bankruptcy application. Complete the debtor's bankruptcy application in Form PIR 9 of the bankruptcy rules available on the website. You will need to affirm an affidavit in support of the bankruptcy application in Form PIR 10 of the bankruptcy rules. Next step, file the application personally or through a lawyer. If you are represented by a lawyer, the application will be filed by your lawyer. If you are representing yourself, you will first have to place a deposit of $1,850 with the official assignee and then find a licensed insolvency practitioner to consent to be nominated as the private trustee in bankruptcy. You will then have to file the following documents via e-litigation at the LawNet and Crimson Logic Service Bureau. All the forms that you have prepared for your application, the receipt for the deposit payment to the official assignee, the licensed insolvency practitioner's written consent, and a copy of the licensed insolvency practitioner's license. The Service Bureau will notify you via email or SMS of whether your application documents have been accepted by the courts. If the court accepts your application documents, you will be asked to return to the Service Bureau to collect an endorsed and sealed copy of the documents. This will include the date and time of a hearing that you must attend. You must attend the hearing on the scheduled date and time. If you are represented by a lawyer, he will attend for you. If you filed a bankruptcy application for yourself and you missed the hearing, your application may be adjourned to a later hearing date or dismissed by the court. If the application is dismissed and you still wish to make yourself a bankrupt, you will then have to file a fresh application and pay the fees all over again. During the hearing, a registrar of the High Court will hear your bankruptcy case. If you are the debtor and you made the application against yourself, the court will ask you what you wish to do. For example, if you wish to obtain a bankruptcy order for yourself, the court may proceed to hear your application and declare you a bankrupt. But before declaring you a bankrupt, the court will consider whether you qualify for the debt repayment scheme. The debt repayment scheme is a pre-bankruptcy scheme by the official assignee. It aims to help eligible debtors with debts not more than $150,000 to avoid bankruptcy through a debt repayment plan. If you fulfill certain criteria, the court can adjourn the hearing for up to 6 months or such other period as the court may direct in order for the official assignee to assess if you are suitable for the debt repayment scheme. If you are found to be suitable for the debt repayment scheme, the debt repayment scheme will start. The court will treat the bankruptcy application as withdrawn and you will have to fulfill your duties as a debtor under the debt repayment scheme. If, however, you are found to be unsuitable for the debt repayment scheme, the court will schedule another hearing for the bankruptcy application. At that hearing, the court may make an order to declare you a bankrupt. However, it also provides a structured framework for debt resolution and protection from creditor harassment. In some cases, it's the only viable option to move forward. I always recommend seeking financial counseling or legal advice before taking this step. Bankruptcy should be seen as a last resort and not a quick fix for financial troubles. Thank you for watching and I'll see you in the next video.